developed on this subject.
Can you articulate something precisely on this? You don't have to do it now. You can file something on this privacy, keeping in mind what 24 hasn't already covered. So those kind of things, or we can come back to it. Can we move ahead?
Sir, sir, as far as Article 19 is concerned, as I was saying before your lordship, sir, that
in your petition you don't challenge this, or do you do challenge?
My lord, I have pointed out that this the privacy aspect of it has not specifically been dealt with, sir. The privacy aspect of it, but Article 19 obviously has been reverted to, sir.
Again, there are two ways to do something. One is to strike down something.
Yes.
The other is to read down something. The third is to interpret something. Our interpretation also, in a way, becomes a law. So keep all these three aspects in mind, because I don't think we should do striking out, but maybe we can do the next two, unless you can persuade us otherwise.
My lord, let me begin with Article 19, sir. Sir, उसमें तीन चीजें important है. One is that the exceptions to freedom of speech is
reasonable.
One, that it has to be reasonable. Number two,
by law.
It has to be imposed by law. Number three, it has to meet one of the 7 objects mentioned in it.
I find 8, you find 7.
My lord,
let's start counting them.
Glory of Islam, integrity, security, or defense, I treat them as one, sir. Two, friendly relations with foreign states. 3, public order. 4, decency or morality. 5.
No. Decency is different from morality.
Okay. Then it will be 8. So okay. I treated decency and morality as part of the same, but then it will be.
I know there's common ground, but I think they're two different. And if the Constitution has used 2 different phrases, who are we to dilute there?
Fair enough, sir. Then in relation to contempt of court, and then this is important, sir, commission of or incitement to an offense.
I think this is the most important one.
Yes, sir. Because your lordship will appreciate that before the 4th constitutional amendment, this specifically included defamation. Defamation was omitted. Defamation was, instead of commission of, it used to be defamation or incitement to.
Defamation was there in the original constitution.
Yes, sir.
And was removed by the 4th amendment.
Yes, sir.
When was the 4th amendment?
So that was 1975.
21st November 1975.
And removed
21 November 1975.
by 4th amendment.
Yes, sir.
4th amendment. 21 November
1975.
1975.
Now, incidentally,
what was the reason for doing so?
My lord,
did you see the whatever the debates or anything like that?
I have not been able to look at the debates, sir.
Okay.
But if I saw the 1956 Constitution,
then I can think of reasons myself. But I was just wondering what had prevailed by the Constitution makers to do so.
Sir, I've not been able to lay my hands on the debates yet. But it was there in all, defamation was there in all the previous constitutions. It was there in the original 73 Constitution, but it was removed in this, in the 4th amendment. Now, my submission is, sir, that the purpose of that removal is to decriminalize defamation. And that is the international trend, that defamation is in many countries, they have, where they had criminal liability.
Mr. Ravi Ahmed, there's another case pending before this court, case of 2 very famous Pakistani singers, where one alleged sexual harassment against the other, and the other resorted to criminal defamation. And one of the questions posed in that is exactly what you're saying. ये है आपके पास reported
Nisha Shafiz and
नहीं वो
Ali
reported
Zafar's,
है या उसका प्रिंट आउट दे दें नहीं नहीं उसमें मेरे ख्याल में एग्जैक्ट एक क्वेश्चन आया so we can leave it for that because it because ये है हमारे पास अच्छा चल I'll continue
My lord, this is important actually, that case also, and I had advised at least one person who received an FIA notice in that case as well for expressing support for what Nisha Shafi had said on Twitter or Facebook.
let's not
And they
argue that case
I'm not arguing it. I'm not arguing
let's
it.
not
What
take
I'm
names
saying
up.
is that Section 20 was applied in that case as well. Notices were sent by FIA on that ground as well. So what I'm saying is that the criminalization of defamatory speech, whether it be done through Section 20 of PICA or otherwise, that would itself fall afoul of the Article 19.
No, I was just thinking, shall we leave it for that? We're just trying to get the order and just see if it covers what you are going to say,
Sir.
because it has not been decided. So I don't want to make that petition redundant, because this very specific question was formulated therein. So can we proceed? In the meantime, if they can just find it and give it to you.
Now, sir, even if a law is promulgated for the objects, the 8 objects mentioned in Article 19, even then it can only pass constitutional muster if they are reasonable.
Yes, sir.
Now, the reasonableness,
ये इसकी एक और कॉपी दे दें हाँ मिल गया It's 2022 SCMR 1267 हाँ सलाउद्दीन साहब को दीजिए You can skip the factual aspects and you can turn to paragraph 4. Leave is granted to consider the following.
whether Section 20 of PICA and any other provision thereof violate Article 19 of the Constitution, whether the defense of truth is undermined by Section 20 of PICA by criminalizing defamation, whether the criminalization of defamation negates, dilutes, and or suppresses the fundamental right of freedom of speech and expression, whether, my lord, this would cover exactly
इसीलिए
some of the terms.
read on.
Whether an anomalous situation is created if both a civil case claiming damages on account of defamation and a criminal prosecution for defamation proceed and or to do so simultaneously, and whether this would undermine the fundamental right of a fair trial and due process enshrined in Article 10A of the Constitution, whether by invoking PICA against victims of sexual harassment and victims of other crimes amounts to silencing them.